Okay, sorry about the 3 minutes delay in getting this started. We had a little bit of technical difficulties in the background for my friend Joe Toombs, but we got it straightened out. So I appreciate your patience. So hopefully you guys had a good day yesterday. You attended the sessions you wanted to get. Don't forget, we're going to have the recordings in about a week. Don't hold me to exactly a week. That's what I've been told. It's a technical thing, getting them ready and processing out to you guys. So, about a week. Like I said, that's what we've been told. We're going to continue with our programs today. We have a lot of good sessions. I'm sure you guys have, hopefully signed up for them by now. But just a kind of a brief overhaul. When I'm done for a few minutes here, I'm going to be handing it off to Joe Toombs, who's going to talk about becoming a registered settlement planner, amongst other various different designations. And if anybody knows about designations, it's Joe. He has more than I think the alphabet will allow. But he's obviously very well qualified to talk about those types of things. We're going to talk about mass torts from an attorney's perspective and how we planner can add value. Tax law with my friend Jeremy Babner. He's always good in his presentation, so I know you guys will enjoy that one. Pooled trusts. We're going to be talking about factoring industry, attorney fee, deferred compensations, emerging markets, a lot of good meaty stuff. And then we're going to wrap it up. I'm going to be hosting moderating a panel, a judiciary panel. We're going to talk about a lot of things that, folks that are right there impacting what we do on an everyday basis, once we get back to an everyday basis that we're all comfortable with again. But those folks that are there to try to help bring settlements together, that's how they keep score. And we need to try to help them, okay, by some of the things that we do. So should be a pretty interesting day. Just a reminder, we have the board of directors elections going on. This isn't Chicago. I don't want you to vote early and often, but I do want you to vote one time for those voting members. That would be great. We have 7 seats available, all excellent candidates. So please, it's a very critical time we're entering now. So really think about who you're voting for, not just because it's a friend or something like that. Think about who's really going to be giving that extra effort, because being on the board of directors for this organization, it does require extra effort, no doubt about it. But hopefully it's rewarding for those. I must think it is, because like I said, the 7 people that are terming out of their board of director commitment are all interested in coming back in. So I think that says a lot about what we do and the feeling that we get working there. So please vote for that board of directors. You should have received the survey by now. We'll send it out again if you've already voted. That's fine. But we're going to keep sending them out, so make sure everybody does that. Okay, so what we're going to do today is I'm going to hand off this presentation to Joe Toombs. He's going to talk about various different designations. Why do we talk about designations on a pretty regular basis? Because it's important. It's our credibility to the marketplace. It's our ability to put better plans together, have a little bit more insight as to how things come along, and the designations help us with that. It's not everything. It's not everything. We have to be good at what we do, but the designations certainly do help, and it certainly does provide some credibility, especially for a settlement planner, which is a profession that's not wildly known, outside of our area here. Okay, so Joe, I hand it over to you. I'll stay in the background, everybody. I'm going to be here to answer questions through the chat line that we have. I opened it up for this session. There's a special reason why I really wanted to have the chat besides just hearing your questions. We're going to have a special offer in the middle of this presentation that I'll come back on and talk to you folks about. So without that in mind, I'm gonna bail out on the camera and the microphone, but I will be in the background, everybody, answering questions. So please throw them out there. Give me something to do. Okay, thanks everybody. Go ahead, Joe. You got it, man.
Okay, thank you, Joe. I'm in a hotel right now, and because of the limitations of having one screen, the way I've worked through this technical issue, I may disappear. I'm not sure. I just want you to know. And my rabbit filter might turn on for all I know. I won't be able to see myself as I speak, but I'm going to share my screen and share a PowerPoint presentation, and we'll talk about that. Okay. So today we're going to talk about expanding your planning network and advanced certifications, as Joe indicated. You know, when I write my name nowadays and put all my credentials down, it looks a little ridiculous. You know, because I have this addiction of getting these. I don't know. Maybe I didn't get enough hugs as a child, and so I'm overcompensated. I'm not sure, but I've always been interested in financial planning and legal aspects, and so I've collected these over the years. As I've said before, you know, they're cheaper by the dozen because as you learn from one, it helps you on the next one and that kind of thing. But I want to start out just taking a little aside and talk about an interview first. No one likes an interview. First, before you go into an interview, you usually summarize your life on a sheet of paper, and you call that your resume. You submit that paper to a stranger, or maybe hand it to that stranger when you walk into a room. That person is in a position of power because you're obviously there to try to get a position or something. And then that stranger looks at your resume and they judge you. They ask you questions about your resume to find out if you're lying about it. And then they make a decision based on incomplete information that's going to greatly affect the rest of your life, perhaps, or at least that's what you feel like the stakes are when you walk into an interview. No one likes that. It's a little more intense when you go into a court situation. And plaintiff attorneys hire experts a lot. That's one of the areas of practicing personal injury law that gets the most attention. If you're ever on a trial lawyer's listserv, probably a third of the chatter is about, hey, is this person a good expert for this? Is this a good, you know, who's the expert? As far as like an accident reconstructionist or a doctor in a particular market. And so a lot of their time is spent picking an expert. Now, one of the reasons they take so much time and they value this is that a case will often turn on the testimony of one or two experts in their opinion. And when a plaintiff attorney picks an expert, as they do on every case, multiple experts, they know that once they designate that person as an expert, that the defense will attack the credibility of that expert and the opinion of the expert. They know going in that whoever they choose is going to have to step up and help them fend off that attempt to get their testimony excluded from evidence. And when the defense chooses an expert, they know that the plaintiff attorney will be making attacks on the credibility of that expert and the opinion of that expert. They will the attack on the credibility goes to the very question of, is this junk science, or is this even admissible? Should the judge allow the jury to hear this expert, to see their opinion, and to weigh it as part of the case? And we call that a Daubert challenge. And then once if the defendant makes a Daubert challenge and begins challenging the credibility of that expert or the methodology behind their opinion, then the judge might schedule a Daubert hearing. And when at the Daubert hearing, the whole subject of the hearing is this person really an expert? Should we listen to their testimony? Or should we let the jury hear about this? And then what's the underlying reasoning and methodology used to form their opinion? And this is based on a Supreme Court case from 1993. And basically the question is this a real expert testifying about real science? And in a Daubert challenge, there are 4 points that the judge has to consider that are laid out in the opinion. One is testing. Has this theory been tested? Is it subject to peer review? Have others had a chance to comment on their opinion of the methodology that's used behind the expertise? And then what are the rates of error so that the jury can understand that this analysis may be flawed because sometimes the analysis doesn't work. And then you have to prove that it's acceptable within the specific scientific community where the methodology is employed. So consider this. Plaintiff attorneys hire experts all the time. If you want to be viewed as an expert, you have to just realize that it's almost a daily activity looking for good experts on different subjects. But they look a lot more skeptically than anybody else that you'll ever do business on, because in the back of their head, they're thinking, is this person really an expert? They're trained to think, can I hire this person and believe what they say and defend what they say from an attack that they know going in is coming. They're going to attack the expert, and they're going to attack the expert's opinion. Before Daubert's, by the way, there was the Fry test, and in some jurisdictions, the Fry test is still the standard. But before Daubert, it was easier. It was basically a general acceptance check test. Is what this expert's opinion is? Does it meet the generally accepted methodology by the scientific community? Has this person had the right scientific training, and is their opinion formed by something that's generally accepted? Notice that that's a much lower bar than the specific expertise that's required under the Daubert challenge. So this is the question I want you to ask yourself, everybody individually. Would your settlement planning practices that you hold right now stand up to a Daubert challenge? In other words, if you were accused of being an expert in the field of settlement planning, would there be enough evidence to convict? Are you an expert in settlement planning, and is settlement planning a field where an expert opinion is necessary? So think of it this way: if opposing counsel rigorously objected to you as an expert, how would you convince them that you were an expert? And would there be enough objective evidence to persuade a judge that you are an expert in the specific field of settlement planning? And then, if that same counsel rigorously opposed the objective evidence that you were, would you be able to say there's enough objective evidence to persuade a judge that your settlement plan reflects the current state of the settlement planning science? And the reason I'm saying this isn't because you're likely to have a Daubert challenge in any settlement plan that you do. Settlement planning is rarely a subject of the trial, and so admittedly, an attorney obviously is thinking of an accident reconstructionist or a certain surgeon in an area of expertise a little differently because they know there's going to be this Daubert challenge. But since they're in the habit of hiring and evaluating experts with that standard in the back of their mind, when you come to them and suggest, I would like to be the settlement planner for your clients, I want you to bring us in on cases, you just have to know they hire experts a lot, and so and they follow this methodology, and you need to know that that this is kind of in the back of their mind. The truth is, you're unlikely to be called as a witness for anything other than a friendly suit, or at least not very often. I think a lot of us have sat in the witness chair as an expert witness in something that's probably other than settlement planning. And on at least one occasion, I was called as an expert on settlement planning and sat in as a witness. And as far as I know, since I was able to do that, then obviously the defendant didn't win a Daubert challenge. You get my testimony excluded. But my question for you is, if you call yourself an expert in the field of settlement planning, could you defend yourself as an expert and that your opinion was formed on the basis of science? If so, where would you even start to say, oh, I am an expert? Okay, one place to start in just about any field is that if someone's giving professional advice, they would start by saying, here are my professional credentials. And here are the professional societies that I represent. Here are articles that I've published. Here's my educational background. Here's the experience where I've been regularly hired as an expert on the field that you are called to testify about. There is testing involved, not only in me becoming recognized as an expert, but also in the methodologies that are employed. I'm using things that are evidence-based. And in this field, there are standards that are being followed. And so if you're going to try to get a person to take you seriously as an expert in settlement planning, one of the first and most important things that you can do is earn a credential in that area. Right now, there's exactly one credential for settlement planning, and that's the Registered Settlement Planner. The Registered Settlement Planner program is one that has 3 courses. They're college-level courses. Each of these courses was taught in a graduate class when they were first developed. The first is Financial Planning for Settlement Planners. The next one is Law for Settlement Planners. And then there's a Settlement Planning Seminar. And then after you finish the educational component and agree to abide by the standards for CE and the ethical standards, then you can submit a comprehensive settlement plan. And at that point, you are awarded the RSP designation. The total cost for the RSP designation is about $4,000. Each of the courses is priced at about $1,000. I think $999 for each of the 3 courses. There's some books involved, and there's an application fee. But the good news is, and I'll ask Joe to come on, we're going to make a special offer for the people who are here attending the SSP meeting, and we're going to offer the RSP at a discount. Joe, did you want to talk about that?
I sure do. Okay, everybody, this is a chance to take a little bit of an investment in yourself to become an RSP. We ran this last year at our annual, and we're going to do it again this year because we just want to get as many people involved as we can. It's not something that we're looking to make money, make a big money maker or anything like that. It's really a designation to help lift all boats in that water. So here's what we're going to do. I'm looking for folks to join and sign up and just give us a verbal or a check off on your decision to try to move forward with the RSP program. If we get anywhere from 1 to 5 people in this conference that agreed to say move forward, we will reduce the price by 25% for all of those folks. If we get to between 6 and 10 people, they give us a verbal commitment now to say, hey, we're gonna look into this, we're gonna do this, we'll take off 35% for everybody. And if we get more than 10, we're gonna discount it at 50%. So that $4,000 would now be $2,000. You spend that over time as you're taking your courses. It shouldn't, hopefully, tough year to be saying this, hopefully won't be breaking anybody's budget to do this, to take the investment. Maybe you have a little bit more time to do some studying. It's not a long, hard course. You do it at your own time. You do it it's all online. Has some great, it's video based for the learning, as well as books and things like that. So in your chat box over to the right, just pop in and say, yeah, I'm interested. I want to start getting a head count here if we can. Just say, I'm in. That's all you have to do. I'm in. It's not a written in stone. We're not going to take your firstborn if you don't, but we just want to try to get a little bit of information, a little bit of momentum going here, and see if we can start, getting our next class of RSP candidates on board. So please jump into the chat. Don't be somebody be first. Last year we had people raising their hands all over the place, and I was having trouble keeping count on everybody. And we did get over the 11 mark, and we have everybody, myself included, that got a 50% discount on the program. So jump in. I'll be watching for those texts, but please, here we go. All right, we got our first one. Thank you, Tacker. Good. Kurt, good. 3. All right, let's go. I feel like it's an auctioneer here. Do we hear 4? 4. We have 3. Do we hear 4? Anybody else out there? I'm sorry, I'm getting a little punchy here, but all right, Samantha, 4. Come on, we need one more. Let's get to 5. We want to actually get to 6. That gets us that next round of discount. There's 5. All right, next person gets us Christy. All right, you broke it. Now we're at 35% discount for this program. 7, 8. All right, we need 3 more to get to 11, and everybody's getting that 50%. 9. Absolutely interested. That's what I like, that commitment, Connor. Beautiful. All right, that's 9. 2 more. Come on, 2 more folks. I'm not a good auctioneer, probably, but let's try to get over that top here. Let's get everybody a 50% discount. We need 2 more. Okay. All right. I'm not going to hold off. This isn't a course for auctioneers training, but the chat is open. 10, 11. Bingo. All right.
All right.
People coming. Let's get 15, 20. Let's get more. We don't want more than that. Michael Good. Absolutely. But if we continue this, we've got our 50% discount, guys. And I'm so thrilled for all of you. That's awesome. Let's build this program. This is the designation. I talked about this yesterday opening. This is the designation that separates you from being all due respect to guys and girls, the structure guy versus the settlement planner expert. This is the one. And the more people we get in here, names will keep coming in. Beautiful. Thanks, everybody. Awesome. We're just building that lineup. The more people we get in here, the more powerful those that have that designation become, because that designation is more widely known. So awesome job, everybody. All right. We are over that hidden comment. We'll circle back and get everybody the information. We're going to keep your names up from the chat. We're going to get everybody the information that have said they're interested. We'll get that thing started. Joe, back to you.
Hey, Joe, you've got a career in public television fundraising.
You think so, huh?
We ought to send out a tote bag to everybody.
I hear that's a very high-paying position of public television. There's a lot of potential there to get my kid through college. But thank you. All right, Joe. I'm not going to steal any more of your thunder. I'm going to back off. Keep watching those names coming in. Tracy, interested, beautiful. I am going to be off mic, but I'm still in the chat room, guys. So keep it going. Thanks.
Okay, thank you, Joe.
All right.
The registered settlement planning program is it really is very good at teaching somebody. The basic goal is to become minimally qualified as a settlement planning professional, and it should be on everybody who takes themselves seriously as a settlement planner. It should be your credential. I mean, that's, doctors go to medical school to become, to learn what they need to become doctors, and then they take a test, and then they become a doctor. The same thing with lawyers and with CPAs. The educational part is required before they can hold themselves out as a professional. And so I'm encouraged to see so many people pursuing that, and we will work very hard to make it a good experience for you. The certified financial planner, I think, is the primary financial planning designation. I think it kind of is the one that the consumers recognize the most, because they've spent so much time marketing it, and that there are enough of the right financial planners in the world have pursued the designation that people now, when they think, oh, okay, that person's a good financial planner. When you think about what we do as settlement planners, we are financial planners. We're part financial planner. We're part lawyer, and we're part settlement planner. I mean, basically, so, and I guess we could probably put in about 6 other fields in that as well. But primarily what we do is we're financial planners for personal injury victims. I would encourage people to look into the CFP program. That's a program that I've been heavily involved with for I guess it's over 30 years now, and would encourage people to look at that as well. The Chartered Financial Consultant is one done by the American College, and it's also a good credential. And after you've passed their course of study, you're also eligible to sit for the CFP exam. Of course, if you want to be an expert in structured settlements, and you know, sometimes people get the terms confused, and sometimes even within our own society, we call ourselves structured settlement planners. I think that's becoming a lot less common than it used to be, as the profession of settlement planning has kind of evolved. But if you want to be an expert in the settlement planning engagement, then you need the Registered Settlement Planning Program. If you want to be an expert in structured settlements, then you need the CSSC designation, and I highly encourage people to do that. I still haven't done the CSSC designation, and I probably will before I get out of this life, assuming I get out of it alive. And then there's a master's in structured settlement consulting as well, that's also administered by NASTA. Yeah, this is a designation. This is the only designation I've added this year. I've had a slow year. I've only added one professional designation to my list. And so I've kind of slowed down on that this year, and I've only added this one, the CFTA. In order to become a CTFA, which is a Certified Trust and Fiduciary Advisor, I encourage everyone to get this whether or not you work for a trust company. In order to get this, you have to meet one of the following requirements: either 3 years of wealth management experience or trust experience and completion of an approved training program, or 5 years of wealth management experience and a bachelor's degree, or 10 years of personal trust experience. So notice, if you have 10 years of experience, you can challenge the exam. What you need to do to get this is to be able to pass that final certification exam. If you take a course of study and then the exam, it costs about $3,500. If you do it the way I did it, you just have the exam fee and application fee, and then you are scared when you take the test. But that is a challenging designation. It's one that I encourage people to get. I'm excited that they changed the name. It used to be, the CTFA used to have the same initials, but it go by a different name. It was Certified Trust and Financial Advisor. They changed that to Fiduciary Advisor, which I think is, that's kind of the hot word now, because people want to hold themselves out as a fiduciary until they get sued, and then they will swear that that's not the standard that should apply to them. But anyway, selling credentials to attorneys. Okay, first of all, I think when we are approaching an attorney and saying, I would like your settlement planning business, I would like you to refer your clients to me when you receive when you settle a case or when you get close to the end of a case. We should frame that engagement just like they're hiring us as an expert. First of all, they know how to do that, so it's an easier close. The main person that you have trouble closing on this type of arrangement sometimes is yourself, because you have to have the confidence that your advice is worth money, and that you are a professional, and experts get paid a fee from the client's share of the proceeds for their opinion and for their help. I would also say experts put together a written report. And then when you're talking to an attorney and you have the proper credentials, you show them your curriculum vitae. It's kind of like, like I have some friends who work out a lot and they're all buff and, they're always inviting us for pool parties. And I have some people who are rich and they're always inviting me to the country club for one reason or another. We always, wherever our strength is, we always kind of want to meet people on that ground sometime. So of course, if I have a lot of credentials, then I usually lead with my credentials. And I like to talk to the attorney and tell them that I went to school for this, that I know what I'm doing, that I have all the professional designations in the field that I practice in. I practice as a professional. I have an engagement letter that defines the scope and the terms of the engagement. That when I give my opinion, I'm willing to put it in writing and put together a plan that shows the analysis that went into the plan as well as my recommendations. And then I'm also willing to provide the attorney with what we call an affidavit of service, basically a sworn statement that promises that our settlement plan will be fiduciary, that we will be complete, and there will be complete transparency. And so if we're going to sell with credentials, any new attorney that we get, we're probably taking from somebody else. They probably had somebody that they've used in the past, sometimes several people that they've used in the past, and we're asking them to use us from now on exclusively. So I think you're going to have to ask the attorney, who have you used in the past? And you'll be able to tell when they describe who they've used in the past, whether they have an affinity toward remaining with the person or if they have a loyalty. Then just ask the attorney if you can see a copy of their last written settlement planning report so that you can make sure that the settlement planning they're getting is the settlement plan of an expert and a professional, or are they still dealing with somebody that's transactional? And then just tell them, could your settlement planner that you've used in the past, could they stand up to a Daubert challenge? Could they prove that they're an expert in their field? Could they prove that they're following the science? And if they're not doing that, then why are you hiring an expert that couldn't even give an opinion in court because it would be thrown out as junk science? And so I believe you should bring a sample of a typical settlement plan that you produce and say, this is our methodology, and I would put it up against anybody else's. And then speak highly of the planner that they've used in the past, but just ask them if they really think they could stand up to a Daubert challenge if they were ever challenged. I believe that a settlement planner should be a quarterback of a team of specialists. Settlement planning is too involved to do everything. We can't be the settlement planner, the financial planner, the insurance agent, be the person's trustee, their estate planning attorney, their special needs planning attorney, offer, hey, we can do multifamily office type of services where we're handling your checkbook and taking care of things like that if need be, or acting as, and we can also do your MSA compliance and your QSF administration. Obviously, one professional cannot do all those things, and if they try to do that, then they can probably take about 20 clients, and they're as far as 20 injury victims, and that's going to about max out the rest of their career if they're trying to do all of these things. As a settlement planner, the engagement is very necessary for what we do. We need to have an engagement, but we also have to have a plan to break off that engagement. In our engagement letter, we should set out the scope of the services that we provide and then it should say when our job is over. And at the end of a settlement planning engagement, it probably will end in a handoff to someone who will take them the rest of the way. But during that time, when a financial plan is a settlement plan, during that window of time, a settlement planner needs to get in there and bring in the expertise and bring in the additional experts that will be necessary to take this financial problem off as a burden from the plaintiff attorney and off as a burden from the injury victim, and help them begin the transition to the rest of their life. I believe that a settlement planner should introduce their clients to the financial planner, who will take them from there at the end of the settlement planning engagement, and that way they've disengaged and they're ready to go and do another settlement planning engagement. I have done literally everything on this list, but I kind of realized that I'm a strange duck. Okay, that most professionals should pick what they specialize in and do it. The way I've designed my practice is that I do offer all of the services on here, fairly limited in some areas, but what I do is I introduce them to a trained specialist who will make sure that the work gets done. I'm there as the quarterback. In other words, I'm supposed to make sure everybody's doing their job, that everybody's job is done in a professional and expedient way, and that we've checked all of the boxes. The settlement plan is completed. It's been implemented, and then once it's been implemented, then I can step back and disengage. People ask me all the time, why did you get more letters after your name than in your name? I get that question a lot when I show all of my designations. And you know, the current count is 29 to 18. There's 18 if I spell out my middle name. I have a long middle name, so I've got 18 letters in my name and 29 letters after my name. I'm not suggesting anybody join me in my illness, okay? I'm getting a lot of different designations. The reason I have those designations is because at the time that interested me, and I wanted a constructed course of study so that I could feel like, okay, I've mastered the material. I have a deep interest in this, and when I meet a settlement planning client, I want to know myself that I'm going to be able to help them, and that I'm going to be able to evaluate whether they've gotten the help that they need and deserve. But that doesn't mean I'm going to fill all those boxes and do everything. In my firm, we've designed the firm so that I can bring in somebody else that's a specialist in some of those other roles, and some of the roles I'm doing myself. But I did it because I have an obsession. If it's a perfectly beautiful Saturday, some people think, oh, I'm going to hook a boat to a trailer and go to the lake, and I'm thinking, oh wow, I wonder if I can pay $1,000, drive 100 miles, and take a test. We can call it a hobby. I get asked, are the credentials worth the time and money it costs to obtain? That question I get a lot, and it's not a question I'm really comfortable answering. They were for me. Okay, I did spend a lot of money. I continue to spend a lot of money on continuing education, because to feed all these designations, you have to go to a lot of continuing education events, because sometimes you can double, triple, or quadruple count something, and sometimes you can't. Obtaining them also involved a course of study and some sacrifice. I would say it is worth it, because to me, that's how I became a settlement planner. I became a settlement planner by learning how to do settlement plans, and same thing with an estate attorney and the other related fields that I'm credentialed in. It was worth it. To me, if I wasn't pursuing a designation in that, I would have been reading articles and listening to presentations on the same subjects, because that's the field I'm in. So I never set out to obtain a credential in order to put another thing on the wall. I mean, my wife came into my office and said, "Oh man, your diplomas look horrible. All the frames are mismatched and everything. You need to get them reframed." And the thought of that is like, "Oh, okay, well, I'll just put my mother's dentures on eBay and try to raise the money to retain a frame shop for a very long and expensive engagement." But are they worth the time and money to obtain? I think yes. I think the answer is 100% yes. If it makes you a better professional, then you'll be rewarded by knowing the right answer at the right time. Now, the other question I get all the time is, do all the credentials help you get clients? I don't. I assume that they do. It does, but I've never had someone come to me and say, "I was referred to you because you have a certain designation." I think as because I was young when I obtained my law license and my insurance license and the CFP. I've always just taken that for granted. I think that would have been fine as a complete set of credentials. I don't think I needed the other 10 or 11. But I don't think that the credentials help me get clients directly. Like somebody says, "Oh, you're a CFP. I want to hire you because you're a CFP," or "Because you're an RSP, I want to hire you." But I do think that I get hired often because I know the answers to questions that I learned in getting the designations. The credential. The truth is that the credential that I spent the longest time in my educational career obtaining, I didn't finish it. The one time I was all but dissertation on a PhD. But I got all of the education during those 4 years, and I think that having all that education and knowing the answers to the questions that I could have only learned through going through that course of study has helped me get clients, even though the credential doesn't hang on the wall. But of course, I would probably have a completely different story if I didn't have some other credentials that qualify me as an expert. Okay, I've got a side note. Indulge me. I'm a proud father of four kids, and I work with 2 of my own children. I was so proud because we moved our office location, so we all needed to get new cards printed. And both of my sons' credentials spilled to a second line. And I was thinking, wow, I've passed on. I've passed something on to the next generation. They've joined me in that endeavor. But experts, advice, and professionals. Professionals charge for advice. To be worth money, advice needs to be informed, unbiased, useful, evidence-based, and follow professional standards. If your advice is just things that you're kind of making up, or you think, "Oh, it's probably like this," it might be able to pass the Fry test, but it's not going to pass the Daubert challenge. If your advice is anything other than informed, unbiased, useful, evidence-based, and professional, then that advice is worthless, okay? And you can't charge for that. The good news is, in our field of endeavor, that there's a lot of compensation that can be made transactionally. You can get paid for facilitating transactions, and that's not professional level advice. That's being a salesperson that's producing something, and you can be professional at that you can be a professional salesperson by being professional in what you do, but that won't turn sales into a profession. I think settlement planning, when practiced properly, is a profession and is emerging as one. Doctors, lawyers, CPAs, they charge because their advice is valuable. The thing that backs up their advice and makes it valuable is that they had to learn it through a prescribed course of study, and then they sign on to standards of continuing education, etc. So my parting message is your advice worth something? Is it worth a professional fee? Would it stand up to a Daubert challenge if questioned? And that's something that we can kind of look at our own practices and our own level of expertise and judge for ourselves. But one thing is for sure, in addition to us judging it, the professionals who hire us are judging that. And the professionals who hire us are in the habit of thinking, is this person really an expert in what they claim to be? And because that is a very tough challenge, knowing that some of the brightest and best attorneys that the defense can hire are going to be hammering them on exactly that. Is that person a professional? And is that advice evidence-based? And since they're used to hiring professionals in that way, you can bet that when they're deciding whether or not to hire you in an engagement, they're kind of thinking of it in the same way. And frankly, that's why personal injury attorneys can be some of the toughest professionals to work with. They're very skeptical when it comes to hiring an expert on behalf of their client and in their case. So with that, I'm going to stop my screen sharing. Joe, did you want to come back in and rejoin us?
I am back, Joe. That was a great presentation. Thank you. I think everybody has to really kind of think about the designations, where you are, where you want to be, how to best utilize it, leverage it, all good stuff. So thank you. That's great. Any questions for Joe? I'm looking at the chat. Just kind of open that up again. By the way, we got 19 folks that have already agreed to at least express interest in pursuing the RSP, Joe. So,
that's great. That would be our biggest class.
Yeah, congrats to all.
If everyone signs up.
Yep, congrats to all. Has anybody got any questions? We only have a few minutes. The next session starts at 9. I'm sure there's phone and bathroom breaks that you might want to be taking before that. But I'm just going to leave it open for a minute. If you have a question, don't be shy. Please, ask this expert here. He can help you out with any designation, as we've already clearly established.
Yeah, I'm an expert in credentials. That's for sure.
The Eskimo Ice Fishing Association is interested in having you as a member, and was wondering if you'd like to be an expert in that area too.
Well, only if I have to pay $5,000 and fly.
That's good. But other than that, right. Okay. Well, it looks like we're good, Joe. I think everybody, is got their information, and on behalf of everybody, thank you for your presentation. I thank all the members for joining us, and get ready for our next series of sessions that begins in about 8 minutes or so.
Okay. Thank you.
Thanks, Joe. Thanks for having us back.